Alright, Subchapter 2, States and Indian Tribes. Title 30, U.S. Standard Code, Chapter 29, Oil, Gas, Royalty Management from Title 30, Mineral or Lands Mining. Chapter 29, Oil, Gas, Royalty Management, and we're on page 21, and we're on Subchapter 2, States, Indian Tribes. 1731, Application Subchapter. Subchapter shall apply only with respect to oil, gas, leaf, federal lands, or Indian tribes. Nothing in this subchapter shall construe to apply to any lease on the outer continental shelf. 1731A, Application Subchapter to lease lands within 3 miles of seaward boundaries of coastal states. Fiscal year 1990, each fiscal year thereafter, notwithstanding provision 1731 of this title, section 1731 through 1736, shall apply to any leases proportionally subject in section 1337G of the title 43, which purpose of those provisions of other purposes shall regard as within coastal state or states entitled to receive revenues from under section 1337G of title 43. 1732, Comparative Cooperative Agreements. A. Authorization Secretary permission of Indian tribe required activities on Indian lands. Secretary authorized to enter into cooperative agreements with any state or Indian tribe to share oil, gas, royalty management information, to carry out inspection, auditing, investigation, and enforcement, not to include collection on royalties, civil suit, criminal penalties, or other payments. Activities under this chapter in cooperation with the Secretary to carry out any other activity described in Section 1718 of the title. Secretary shall not enter any other such cooperative agreement with the state respective of such activities in lands except with the permission of Indian tribe involved. Access to royalty account information except as provided in Section 1733 of the title pursuant with the cooperative agreement. Each state shall, upon request, have access to all royalty account information in possession of the Secretary respecting the production, removal, state oil, removal or sale of gas, oil or gas from leases of federal lands within the states, and to each Indian tribe shall, upon request, have access to all royalty accounting information in the possession of the Secretary respecting production, removal, or sale of oil or gas from leases on Indian lands under jurisdiction in such tribes. Information should be made available in paragraph 1 and 2 as soon as practicable after it comes into possession of the Secretary after October 1st, 1983. Such information shall be made available in paragraphs 1 and 2 no later than 30 days after information comes in possession of the Secretary. Alright, C. Agreements in accordance with Chapter 63, Title 31, Terms and Conditions. Cooperative agreement entered for the pursuant in section in accordance with the provision. Chapter 63 of Title 31 shall contain the such terms and conditions Secretary may deem it appropriately consistent with the purpose of the chapter, including not limited limitation, use federal assistance to those costs which are directly required to carry out the agreed upon activities. 1733, information availability, confidential information by the Secretary pursuant to cooperative agreements and conditions, trade secret, proprietary, other confidential information will be made available by the Secretary pursuant to the cooperative agreement to the state Indian tribe upon request only if one such state or Indian tribe consents to writing and restrict to disseminate of the information of those who are directly involved in the audit investigation under this chapter who are needed to know. Such state and tribes accept liability wrongful disclosure. In such case, if the state demonstrates such information essential to conduct of an audit or investigation or litigation or subsection 1734 of this title. In this case, Indian tribes such as tribes demonstrate such information essential to conduct of an audit or investigation waives severe sovereign immunity by express consent of the wrongful disclosure of such tribe. B. Non-liability. United States for wrongful disclosure. United States shall not be liable for wrongful disclosure by individual state, Indian tribe, any information provided such individual state or Indian tribe pursuant to any cooperative agreement or delegation authorized by this chapter. Law governing disclosure. Whether individual state, Indian tribe has obtained possession of information pursuant to the cooperative agreement authorized in section, or an individual state has obtained possession of information pursuant to the delegation under section 1735 of this title, individual shall be subject to the same provisions of law. Respect for the disclosure such information would apply to any officer or employee of the United States or any other department agency thereof in the state of the Indian tribe, subject to the same provision of law. Respect to the disclosure such information would apply to the United States or any department or agency thereof. No state or state officer or employee who receives trade secrets, proprietary information, or other confidential information under this chapter may be required to disclose such information under state's law. Alright, 1734, state suits under federal law, action, royalty, interest, civil penalty, limitations, notice of suit, and award of costs and fees. A state may commence a civil action or section against a person to recover royalty, interest, civil penalty, which the state believes is due based on credible evidence respect to the oil and gas lease on federal lands is located in the state. 2A. Notice for any commencement on paragraph 1 prior to 90 days after the state has given the notice in writing to the Secretary of the payment required section. Such 90 days limitation may be waived the Secretary on a case-to-case basis. And within 90-day period specified in subparagraph A, Secretary issue the demand of the payment concerned with no action commenced on paragraph 1 respect with the sum of the payment due with the 45 period after issuing the demand. If during the such 45-day period Secretary receives payment in full with no action may be commenced on paragraph 1. If the Secretary refers to the case of the Attorney General of the United States within 45-day period referred to subparagraph B within 4 to 10 business days after expiration such 45-day period, no action may be commenced on paragraph 1. Attorney General within 45 days of the referral commencement thereafter diligently prosecute a civil action in court of the United States with respect to the payment concerned. 3. The state shall notify the Secretary Attorney General of the United States of any suit filed with the state under this section. The court issuing any final order in action brought under paragraph 1 may award costs, litigation, include reasonable attorney, expert witness fees to any party to such action, and court determines such an award is appropriate. B. Venue, jurisdiction, district court. Any action brought under subsection A of this section may be brought with the United States of the district court for the judicial district which the lease site or leasing activity complaint or is located so the district court shall have the jurisdiction regarding the amount of controversy of citizens of the parties to require compliance or order the payment in such action. C. Recovery and civil penalties state with the deposit of rent, royalty, interest recovery in the Treasury of the United States. Notwithstanding the provision of the law, civil penalty recovered state under subsection A shall be retained by the state, may be expended within such a manner for such purpose the state deems appropriate. Any rental, royalty, interest recovered by the state under subsection A shall be deposited in the Treasury of the United States in the same manner and subject requirements. Same requirements as applicable in the case of any of the rent, royalty, interest collected or any officer or employee of the United States, except that such amounts shall be deposited in the Treasury no later than 10 days after the receipt by the state. 1735. Delegation, royalty collections, and related activities. Authorization of Secretary. Upon request of any state, and the Secretary is authorized to delegate in accordance with the provision of this section all parts of the authority responsibility of the Secretary in this chapter. Conduct inspection, audit, investigation, receipt, process, production, financial report, correct errors, report data, perform automated verification, issue demands, subpoenas, orders, performs reconstruct, accounting, royalty management, enforcement purposes. To any state with respect to federal lands within the state, prerequisite after notice opportunity for a hearing, Secretary authorized delegate such authority responsibly granted with the section as the state has requested. The Secretary finds that it is likely that the state will provide adequate resources to achieve the purpose of the chapter. 2. The Secretary of the state demonstrated that it will effectively, faithfully administer the rules and regulations of the Secretary under this chapter in accordance with the requirements of subsection C and D of this section. Such delegation will not create unreasonable burden on any leaser. State agreed with it to adopt a standardization reporting procedure prescribed in the Secretary for royalty and production accounting purposes unless the state is effective with the parties, including the Secretary, unless otherwise agreed with the state or agrees to file with adherent regulation guidelines issued by the Secretary pursuant to the mineral leasing laws regarding valuation of the product, which is necessary for the state has the authority to carry out and enforce delegated activity. The state agrees to enact such laws and promulgate such regulations are consistent with relative federal laws and regulation with respect to the federal lands within the state. C. Rules or inconsistency with the state proposal. After notice opportunity of hearing, Secretary shall issue the rule as consistency with the state proposal with the provision, section, regulation, and section D. Within 90 days of the submission of such proposal, unfavorable ruling, Secretary shall set forth reasons thereof and state whether the Secretary will agree, delegate, and state if the state meets the conditions set forth in such ruling. D. Promulgation standards regulation with respect to delegation. After consultation, state authority, the Secretary shall rule with the promulgate within 12 months after the August 13, 1996. Standard regulation pertaining to the authority responsibility delegated under subsection A, including standards regulation pertaining to the audits to be performed, records, accounts to be maintained, reporting procedures to be required in the states under section, receipts, process of the production, finance report, common direction, that erroneous report data, performance of automated verification, issue standard guidelines in order to avoid duplication of effort, transmission report of the data secretary, issuing the demands, subpoenas, orders to perform restructured accounting on the royalty management enforcement purposes. Such standards regulations shall be designed to provide reasonable assurance of the uniform effect of the royalty management system will prevail among the states. Record sharing accounts under paragraph 2 shall be sufficient to allow the secretary to monitor performance under this section. E. Revocation an issue of the demand or order by Secretary if after notice by opportunity for a hearing, Secretary finds that any state in which the authority or responsibility of the Secretary has been delegated under this section in violation of any of the requirements section or any of the rule thereof, their affirmative finding by the Secretary under subsection B can no longer be made. Secretary may revoke such delegation if then providing with a written notice delegated state any reasonable opportunity to take corrective action requested by the Secretary. Secretary determines that the state has failed to issue the demand or order federal leasers within the state. Such failure may result in underpayment of an obligation due to the United States by such leaser, and some of the underpayment of the uncollected secretarial intervention. Secretary may issue such demand or order in accordance with the provisions of the chapter prior to the absent withdrawal of delegated authority. Have compensation state for cost delegation and allocation of the cost. Subject to operations, the Secretary shall compensate any state for those costs which may be necessary to carry out the delegated activities. Section payment shall be made no less than every quarter during the fiscal year. Compensation to the state may not exceed the Secretary responsibly anticipated expenditure for the performance of such delegated activities by the Secretary. Such costs shall be allocable for the purpose of Section 191B of this title to the administration enforcement laws, providing the leasing of any offshore or interested land owned by the United States. Any further allocation costs in Section 191B of this title may be made by the Secretary of Oil and Gas Activities. Other than those costs, compensate states delegated activities under this chapter shall be only the costs associated with onshore oil gas activities, may not include duplication costs allocated pursuant to the previous sentence. Nothing in this section affects Secretary authority to make allocations under Section 191B of the title non-oil gas mineral activities. All money received from the sales, bonuses, rentals, royalties, assessment, interests, include many claimed but to be due owing pursuant to the delegation under this section shall be paid to the Treasury of the United States. Alright, G. Judicial review. Any action Secretary approve or disapprove of the proposal submitted to the state under the section shall be subject to the judicial review in the United States District Court, which includes the capital of the state submitting of the proposal. Existing delegation, any state operating pursuant to the delegation existing on August 13, 1996 may continue to operate under the terms of any condition delegation except to the extent of that the revisions of existing agreement is adopted pursuant to this subsection. Alright, 1736, shared civil penalties. Amount equal to 50% settlement of any civil penalty collected in federal government under this chapter resulting from activities conducted in the state Indian tribe pursuant to cooperative agreement under Section 1732 of the title shall be under delegation under Section 1735 shall be payable to the state, such state or tribe. Any payment under the section shall be reduced by an amount equal to any payments provided due to such state or Indian tribe under cooperative agreement delegation applicable during fiscal years to which civil penalty is received by the total amount provided due to the fiscal year. Subchapter 3, General Provisions.